Welcome to Red, White, and Blue. From the right, I'm Gary Polland.
And from the left, I'm David Jones.
This week on Red, White, and Blue, an in-depth discussion on the forthcoming Supreme Court rulings on critical cases facing that court. Joining us tonight are first, Professor Craig L. Jackson from the Texas Southern University's Thurgood Marshall School of Law. Next, Rebecca Robertson, Legal and Policy Director of the American Civil Liberties Union of Texas. I don't know why I have a problem with that, David. And finally, Professor Leslie Griffin from the University of Houston Law Center. She may have been one of your law professors.
She taught me all I knew.
Well, then,
but I forgot. Thanks to all of you for being here. Craig Jackson, how long have you been at Thurgood Marshall? And pick the case that is coming up that you most look forward to from the Supreme Court.
I've been at Thurgood Marshall. It's my 22nd year. So I've been there a long time. And the case I am looking most forward to, a lot of people are too, is the Affordable Care Act litigation that basically addresses the issue of whether or not Congress can, among other things, the big sub-issue in this litigation is this issue about the individual mandate and whether or not Congress can require individuals to purchase insurance, health insurance. And the reason why the individual mandate is there is because it's an economic argument, basically to create a pool of insurance that will give insurance companies the incentive to provide the kind of care, the portable insurance that they can take from job to job, the coverage of pre-existing conditions. But in order to do that, you have to incentivize that. So you do so by requiring everybody to have a minimum level of insurance. Those who aren't currently insured will have to buy insurance under the individual mandate. That's before the Supreme Court, among other aspects of the
And we certainly want to hear what you think later on about the mandate to buy broccoli. I mean, if you could hold on to that thought, if you will.
Cauliflower's better, but
yeah.
We can always.
Rebecca Robertson of the ACLU, what is it that the Supreme Court is about to do that's most, challenging to what you do for a living?
Well, there are lots of cases that we are watching. Of course, we're always monitoring what's on the court's docket. But the case that was argued yesterday over Arizona's SB 1070, the state immigration laws that the government is arguing really impinge on federal authority to control immigration, is one that we are watching very carefully, not least because states like Texas have in the past looked at enacting such laws and could do so again in the future.
Leslie Griffin? What are you most afraid of, I should ask you probably, from this Supreme Court?
Well, of course, my students and I are very interested in the Fisher case, which comes out of the University of Texas, and that case involves affirmative action, so-called affirmative action programs at UT. Back in 2003, the Supreme Court upheld a University of Michigan program that says that you can take race into account in college admissions as long as you do so in an individualized fashion, usually involving full file review. And the interesting question on the facts in Texas is that, of course, UT has the top 10% program, which is a race-neutral means of allowing students into the school. You take the top 10% of all the high school students in Texas and you let them in. But in addition to that plan, UT said it still needed a Grutter-style individual file review because its diversity needs were not met by the 10% plan. Now, when Justice O'Connor wrote the opinion in 2003 in Grutter, she said, well, it could be another 25 years that we need affirmative action programs. And so it would be interesting to see if the court says no, almost 10 years was enough, no more individualized review, or what would happen.
Well, Professor, let me ask you, if we got rid of the 10% rule and the Supreme Court decided that race decisions are not allowed in admissions, then doesn't it go to individual file review anyway? Can't the university basically admit whoever they want?
I think what they would say is you could have only the 10% rule, because the trend on the court is to say any consideration of race is always unconstitutional.
Okay, so I guess that means that on the application, no pictures and no race listed in it, so then they couldn't consider it.
So, Craig Jackson, you got to be happy that they're not going to be considering race any further at the Supreme Court. It's just not going to be allowed to enter their brains.
That's remarkable. That the Supreme Court this said 9 years ago that race was appropriate, and I think the argument in this case is that because the 10% plan has apparently, at least in the eyes of the petitioner in this case, has apparently worked well, there is no need for any further affirmative action programs. That was actually sanctioned by the court in the Grutter decision. Because they're saying the argument seems to be that the increase or the improvement in terms of diversity at the University of Texas campus, this is not the law school, this is just the main campus itself, has been negligible compared to the 10% plan, and they don't need both. So this is basically the argument that they're making.
Have you seen retreats, if you want to characterize it that way, on race-based policy decisions in the United States in the last 10, 15 years that bother you?
Well, certainly the Parents Involved decision a few years ago. I think it dealt with secondary and primary school kids, and
that was in Seattle.
Seattle and Louisville, Kentucky. There was a second companion case as well. It dealt with choice and programs to consider race, to get students in certain magnet programs. And the Supreme Court said that wasn't appropriate, said that these plans weren't narrowly drawn. I think the attorneys for those school districts thought they were following Grutter. Supreme Court told them otherwise. So there's confusion out there. Apparently, higher education is different from secondary and primary education when it comes down to the use of race.
And I suppose it's possible in this case, in Fisher, that the court could say that the University of Texas is just not following the guidance that's already been given under Grutter, and could say the policy falls, but affirmative action stands. But I think that most court watchers would say that the reason the court has granted cert is because it's really interested in overturning Grutter.
Interesting. Well, I want to, if I could go back, Professor Jackson, to Obamacare, which you call the Affordable Care Act. I understand there's two ways of spinning it, but I was concerned about President Obama's speech basically attacking the whole idea of judicial review. That's what I heard. It sounded like a Rooseveltian court attack because he was fearful that the court may decide that his pet project is unconstitutional. Should it matter where the bill comes from and whether the court decides whether it's constitutional or not? I mean, we have a constitution.
Well, no, the idea behind judicial review is that the court does act as a check on the Congress. But the judicial review, it's been controversial since Marbury versus Madison, and it's remained controversial throughout. And I guess most people disregard it as part of the system, and it is. But you even heard in recent times criticisms of the federal judiciary, that it's important that the federal judiciary not insert itself in the decision-making. It's unelected. It's not the democratic part of the federal government. The democratic branches, the legislative branch and the executive branch, those are the democratic elected parts. They should be deferred to. And you always hear the idea that judges should not be in the business of making law. Well, that's essentially what the president said. Not to take away the authority of judicial review, but it suggested that the courts should be very deferential and very careful in how they use judicial review. It's not their role to second-guess the Congress.
Unless Congress is controlled by Republicans, and then we need to have second guessing.
I want to add one thing. It's not their role to second guess the Congress, except in matters involving civil rights and civil liberties. The court has spoken on that. That is a separate matter.
Well, it's interesting because you say that, because what I find, and this is objectively speaking, see if you all agree, that it depends on the issue as to whether you want the court to intervene or not. For example, if you're for gay marriage, you want the court to strike down the laws that prohibit gay marriage because it's easier to get the court to do it than it has been to do it legislatively in a lot of states or federally. So in that case, you have the left in America wanting the courts to do that, but then when it comes to Obamacare or the Affordable Care Act, then they don't want to do it. So wouldn't you say it kind of just depends on your issue of when you want the court to get involved or not get involved?
No, I think you'd say that it depends on whether the case is presenting a question of, as the professor said, something where Congress has made a deliberate action in an area that is clearly within Congress's purview, or whether it's a case where the majority is trying to impose its will on the minority in a way that our Constitution doesn't allow. And in that kind of a case, as the professor said, we've got a tradition of the courts being a check not only on not only on legislative bodies, but also on the majority's ability to impose its will on a persecuted minority.
Okay.
And so that's the gay marriage example that you're mentioning.
What's going to happen with the Obamacare decision? Any predictions?
The surprise, I think, I was predicting, before the hearing, I was thinking that possibly Antonin Scalia might vote in favor of retaining the bill, but then after hearing his questions, I don't think that anymore. But I do think that the Chief Justice and Justice Kennedy will join the liberals on the court, and I think it will be a 6-3 decision.
Interesting.
Is the same thing going to happen, do you think, Leslie Griffin or Rebecca Robertson, with the Arizona decision that was much discussed recently, where it seems to me like, if you're listening to, as Craig Jackson was with the Affordable Care Act discussion on the Supreme Court, that if you're reading the tea leaves with Arizona, that, oh my gosh, they might actually allow this thing to go through. And is that troubling at all to you?
But before you answer that, I think it's important that you explain what you believe a decision that David's talking about would mean to immigration laws in the United States and among individual states. Because we've talked about it generally, and we're like insiders, but I think our viewers are interested in what would it mean?
It's a great question, and I think it's one that is misunderstood. I think some people think that depending on what happens with the SB 1070 challenge, that could be the end of the conversation about whether states have the constitutional authority to draft their own laws on immigration and will have this 50-state patchwork. Whereas before, for 100 years, we've had jurisprudence that says, no, this is the province of the federal government. But I really don't think, whatever happens in the SB 1070 case, that it's the last time we'll talk about this. The only thing that's at issue right now is whether the federal government has preempted the ability of the states to act in this area. Even if the Supreme Court says that the states can act, we still have challenges percolating their way up through the courts that have to do with racial profiling. That's not at issue in this case. And frankly, we also have, I think, a groundswell in the states of people saying, maybe this wasn't such a great idea in the first place. Maybe getting into this area on a state-by-state basis is not going to give us the benefits that we thought it was going to give us. And we're seeing some states sort of having second thoughts about the laws that they've passed.
Is you and the ACLU, are you concerned that if the court affirms the Arizona plan, that we can look forward to Texas coming forward with a similar plan in the next session of the legislature?
Well, I think that we will certainly, in the next session of our legislature, see some immigration legislation introduced. But, in the last session of the legislature, we had those kinds of things introduced. And a coalition of business leaders and law enforcement professionals and civil rights advocates stood up and said, all of us think this is wrong for Texas for very different reasons. And those measures were defeated. And I would like to think that that's what would happen in Texas, regardless of what happens with SB 1070.
Did anybody see racial profiling as an inevitable byproduct of the endorsement of Arizona?
Well, it's very interesting that at the oral argument in the case yesterday, the Chief Justice began the questioning by making clear that racial profiling is not an issue before the Supreme Court. And so everybody commented on that, right? The racial profiling challenge will come up in cases presumably brought by the ACLU. But everyone was wondering why the Chief Justice went out of his way at the beginning, and the attorneys were also kind of stopped another time from saying the racial profiling issue is not before the court. Only the preemption issue is before the court. So don't think that we're making any stand or reviewing the issue of racial profiling.
So preemption meaning that I know that there might be a challenge to the Arizona law wherein Arizona is trying to talk to employers and criminalizing the employment decision making, as I understand.
Well, there are different things going on in the Arizona law. The Arizona law allows the police to question the immigration status of someone they've arrested, but also to stop someone that they think might be deportable. And those features are a little different from the laws also creating state crimes, that if you apply for a job and you're not a citizen, or if you are in the state without papers. And so I think that the oral argument didn't spend any time on Arizona's crimes, which is the harder question, right? Does Arizona have the power to identify crimes regarding immigration? Because the Constitution gives the power over immigration to Congress, right? So if Arizona might not be able to create states, but people listening to the argument seem to think that the other features might still be upheld, that the court might say that Arizona could check
So the show me your papers provision, as it's often called, would be the one that got the most focus, and is the one that I think court watchers think has the best chance of being upheld. But you're right that not a lot of attention has been paid to the criminalizing of conduct that the federal government has said is not criminal.
So do you think anybody from Canada who's driving through Arizona has to worry though about being stopped and with some suspicion about their credentials as far as being in the country legally?
They got Canadian plates.
Or is it just going to be people that look a little bit more like you,
right.
Craig Jackson? That's
the problem, I think, with taking the profiling off the table. Obviously, there's no cause of action yet because the law has not gone into effect.
Right.
But that is a concern. Right now, they're focusing only on the preemption issue. But one thing I think it's interesting, though, and you pointed it out just now, that and they talked about this during an oral argument, if, in fact, a Arizona law enforcement officer calls immigration and says, we have this person doesn't have papers, do you want them? And immigration says no. Well, they can be held under Arizona state law. And that's a big concern, I'd imagine, under the provision of 1070.
What's likely to happen given that Justice Kagan is not going to be involved in the decision in Arizona since it might be a 4-4 tie? What happens then?
So if there's a 4-4 tie, the lower court decision stands.
And
there would be no precedent based on what the Supreme Court had ruled.
How likely is that to happen? Ms. Griffin?
Well, I think it'd be 5-3 before it's 4-4. I don't think it'll be 4-4.
Uh-huh.
Tie goes to the runner, David.
And that's the Ninth Circuit out of California, then.
Right.
Correct.
And the Supreme Court doesn't like the Ninth Circuit, as I hear. Right? So
Right.
no one identified the big case that George Will is most concerned about in an article I read recently where he says, teenagers, life without parole, even for murder, cruel and unusual. Was that not a remarkable view for a conservative to make?
No, it's not, David.
Okay,
I mean,
well.
George Will is a reasonable conservative.
So that one goes down now that Mr. Will has made his decision, do you think?
I'm not saying that. We'll have to see what the Supremes are saying about that.
Well, he parties with Mr. Scalia, so I figured that meant that...
That he has influence?
In the oral argument, it seemed clear that Justice Kennedy was looking for, as he frequently does, Justice Kennedy, always the swing voter, was looking for a middle ground, right? Mm-hmm. The lawyers for the 14-year-olds who committed the crimes were asking for a categorical rule, right? That no life without parole for juveniles in homicide cases. And Justice Kennedy said, well, what if it's only states that have a mandatory requiring of life? So 80% of the juveniles are in states where once they're convicted, the sentence of life without parole is mandatory. So there's no discretion by judges and juries. And so Justice Kennedy suggested that, well, what if we just get rid of these mandatory ones and send things back to the wisdom of the jury and the wisdom of the legislature?
Well, that means certainly David would consider that an improvement. I want to talk about a Supreme Court case that's coming, and that's going to be the voter ID bill for Texas that the Justice Department has challenged. That will end up resulting in a challenge under Section 5, I believe,
right.
of the Voting Rights Act, which this court has been eager to get its hands around for a while. So, any takers on what's potentially going to happen there?
Well, the ACLU of Texas and our National Voting Rights Project is actually representing some interveners in that case, and so we are vigorously opposing Texas's position that the photo voter ID law is acceptable under the Voting Rights Act, and we certainly plan to fight any attempt to overturn Section 5 of the Voting Rights Act, because we believe that when Congress extended the Voting Rights Act, it had a solid basis after a great deal of testimony and hearings for concluding that minorities in the United States still need the protection.
And I think the
Section
argument
5.
on the other side is, that was a long time ago and things have changed and now we can move on from that. And I think there is at least some sentiment of whether it's a majority on the court or not to saying that it's the time for Section 5 under the Voting Rights Act is passed.
Because, of course, Craig Jackson, we're in a post-racial era.
Right.
That's what I've heard. One of the arguments that Texas makes, I think the main argument, they're taking the reasoning or the logic or the holding of a case that came out in 1976 called Washington versus Davis, that required that in order for there to be a successful litigation against the state for discriminating, they'd have to prove intent under the Constitution. And essentially, they're saying that these voter ID laws, at least the voter ID law in Texas, is you can't prove intent to discriminate simply because someone has asked for an ID. Now, the Texas position is that this is identical to a decision involving Indiana's voting ID law several years ago. Indiana's one of those states that's not covered by Section 5 because they don't have a history of discrimination in voting prior to 1964. But in large part, the Indiana decision was based upon the fact that the attorneys in that case did not actually prove how damaging the voter ID law or requirements could be in those specific cases. At least that was the position taken by Justice Stevens. So I don't know whether the Indiana law actually applies directly to this case, but we'll see when the litigation gets started.
Predictions on Voting Rights Act surviving? Anybody?
Well, I would hate to think that the Supreme Court would dismantle what has been the most successful Civil Rights Act in the history of civil rights legislation.
And what if that happens, Rebecca? And what if there is a holding that Affordable Care Act and the mandate part is unconstitutional? And what if it happens that the race-based admissions ruling comes down against the University of Texas? Could we not then agree with your colleague David Dow, who says that would mean we have a renegade, radical Supreme Court that can only be corrected by the voters? Or impeaching them, he said recently in an article. So, what's the correction to a renegade radical Supreme Court?
Right. The obvious thing is
Impeaching
that presidential elections always matter for the court because you never know when a justice may retire or be taken ill. So, in every presidential election, people might talk about other things, but the court's always at stake. It's surprising to me that President Obama rarely gets credit for having put 2 nominees on the court. Right. President Carter never got to put anyone on the court in his 4 years.
Thank goodness.
What about? What are solutions?
I want to ask. Do you all
agree
agree with Professor Dow that we should now be impeaching Supreme Court judges because we don't like their decisions? Is that what we want to do? That seems to me like taking the rule of law and spinning it on its head.
I think it goes back to your earlier questions about President Obama speaking about the court. Sometimes we forget that the court doesn't stand alone with the Constitution. The Congress and the President have their own obligations under the Constitution to interpret it, to abide by it, to follow it. And so I think it's important for us not to think it's out of line for the President to criticize the court or for members of Congress. I wouldn't follow my good colleague all the way to impeachment, but I think we have to realize that it's not inappropriate for citizens to criticize the court or question the court. And right, it's our court. It's our Constitution.
Yeah, and within a limited scope, the Congress can guide the court a little bit in how legislation is written, and also with regard to the jurisdiction of the court to hear certain cases. You don't want to use that too much because that gets a little crazy when Congress tries to determine how the court and what kind of cases the court would rule. But those are alternatives if Congress is totally dissatisfied, which depends upon how the electorate votes. But if Congress is totally dissatisfied with the federal judiciary, they can certainly make an attempt, at least, to
it is clearly fair to say that Obamacare was not overwhelmingly supported by the American people or by the Congress. It barely passed the House. And a number of the Democrats who voted for it now have regret, who are now out of office, said, we were lied to. Most of them never even bothered to read the bill. So, it's...
But if the court strikes it down 5-4, would you say it's not a win? It's not really a win because it was a close vote, right?
Well, no, in that case, it's going to be a win. In my mind, it's a win for the American people.
Congress, right?
However,
if it passes Congress, it's the law.
Well, it's still a win for the American people if we strike it down as unconstitutional. However, we do need to deal with a lot of medical issues that you mentioned, sir, in your opening remarks. They're still out there. Even if it's struck down, it doesn't mean all those problems we have in our system go away. It doesn't mean that at all. And I think most thinking Americans understand that we still then we have to roll up our sleeves and probably this time see if we can actually get bipartisan support. Even if a Republican president, you still have to have both sides buy in and invest and figure out a plan to try to come up with a system that actually functions.
Like a single
doesn't
payer,
break
which
the
is
country.
obviously constitutional, right?
I had not thought about that yet, and
Well,
I didn't research that one.
you know, it's either that it's constitutional, or as Mr. Holmes said, you know,
Well, the
the
problem-
Republicans are coming back up with an enactment of social Darwinism.
Well, the problem with the individual mandate is the question is whether or not Congress has the authority to do so under the Commerce Clause, and conservatives are saying no. Well, that's not necessarily the case. In fact, in my view, that Congress does have the authority. But if the individual mandate is overturned, the individual mandate was resorted to because I don't think the Democrats in Congress thought they could get a single payer through Congress. It wasn't their first choice, I'm sure. So
the operating principle is that they will be able to secure the mandate for health care, but not for broccoli. I mean, is that
Well,
that's going to be the limiting principle
that's
of the Supreme
I
Court?
believe we got broccoli at the oral argument, but it's a good reminder that oral arguments and litigation do
They
come
matter,
back to
don't
who
they?
frames. No, the whole thing is who frames the issue.
Thank
right?
you, Ms. Griffin. Thank you, Rebecca.
Eat your broccoli.
Thank you, Craig Jackson.
Thanks for having us.
You bet. We invite you to
Thank you.
visit our home online at HoustonPBS.org. Click on the local program bar, red, white, and blue. Read about our guests, watch the shows along with a follow-up discussion. And until next time, get informed and get active.